step outside your training and think of a world without institutional facts. And you still have objects, right? So this is still a thing, right? And I'm still doing something with the thing. Would we call it owning it? If we're in a pre-institutional world, am I owning this book at the moment? No, no. Ownership is an institutional fact, right? What am I doing? Holding it and possessing it, okay? I'm excluding you from holding it by my fact of possession, all right? So in a pre-institutional world, we still have possessions, and we still have, no. We still occupy space, for instance. But we don't have the institutional terms like ownership. I claim that the rights, the justice of laws that give us rights to property, like land and movables, is based upon something that, now this is another philosopher you will never have heard of, Adolf Reinach, who wrote he was a lawyer philosopher, so dear to my heart. He described certain sorts of institutions as grounded. And this was long before Searle talked about the notion of brute facts. But he was describing the same thing. He said, contracts are just because they are grounded in the fact of actual agreements among people. And when people make actual agreements, something new arises in the world, an obligation and a duty, right? And that happens, according to Reinach, again, pre-institutionally. So contracts arise because of brute facts, and I say, and this Reinach didn't talk about this, but I say that the justice of laws that enable us to exert our rights over land and movables are also grounded in brute facts. The brute fact of my possession of something is what makes laws that enable me to sue you or the state to criminally prosecute you when you take it from me grounded and therefore just. Okay? Questions about this? And now I have a psychological explanation for this, and that is that we have created institutions that are basically supposed to prevent violence, right? And prevent the use of force. So you don't have to buy that part. All you need to buy so far is that there's some justice to laws of possession that we call ownership in institutions, based upon something that exists pre-legally. Okay? But as all of you know, and this is not, I mean, there are some theorists who dispute this, but there's no way to exclusively possess, the way I can exclusively possess a book, what we would call an expression type. All right? So the intellectual property law recognizes the distinction between types and tokens. Again, this is a philosophy term, types and tokens, describe two different real things. The novel, right? Well, this book, for instance, what is the token? The token is the actual object, right? With the particular words on pages, etc. The type, though, is different. And what is the type? Somebody? Anyone? The ideas, the particular string of words strung together in a certain way. So my possessing this token, what does it do to the type? Anything? Nothing, right? Because you can also possess another copy of it. You could maybe read it and memorize it and carry around in your head the type, right? So it's a very different sort of possession. And there's no way, there's just physically no way, and intellectual property law recognizes this, to exclusively possess an expression type as opposed to the token. And any attempt by you to try to dispossess me of the type, right, by maybe reproducing it, etc., that's not actually going to cause violence, and it doesn't require force, right? Once I have expressed that type, it is out there in the world, and it doesn't do anything to my individual autonomy. Peter comes up to me and he rips this book from my hand. That's that's a very different act than if he, surreptitiously memorizes my book and then goes home and types it. Okay? Unlike land and movables, intellectual property laws are not grounded in any brute facts of possession. Okay? As I said, just laws, according to Reinach, and I agree, are grounded in brute facts. The positive law could be unjust if it conflicts with grounded laws. Now, there's all sorts of positive law that isn't grounded in any brute facts. Rules about where you smoke or park your car. We could argue about that, but I think those are less clearly grounded in brute facts than those of possession of movables and land. But if we consider a regime that outlawed private property, right, and said private property is theft, there have been such regimes. We could criticize, based on this theory so far, those regimes as being unjust, because the justice of the rights to land and movables, I say, is grounded in brute facts. Intellectual property law is a pragmatic response to the logical problem of the fact that you can't possess an idea type to the exclusion of others. And it is an attempt to try to create an economy, to try to deal with this, to spur innovation through increasing profit for those who have monopolies. Okay. Any explanations required so far before the next premise? Okay. Premise 3, and this is where I'm getting slightly more heretical. There are parts of the world that cannot justly be owned. And I'm going to try to defend that based on the argument I made about gene patents in this book. And it has to do with this notion that if there are positive laws that conflict with grounded rights, we have to consider whether or not they are potentially unjust. And I looked at the problem of genomes. So a brief introduction to the problem of gene patenting. All of you might have, there's been a lot going on here and in the media about gene patents, but just a brief introduction to the question of gene patents. This is a process that started in the early 90s. It actually started at the NIH. So I had the great honor yesterday of interviewing Dr. James Watson. Anybody heard of him? Okay, Watson-Crick, they discovered the structure of DNA with the help, and often sometimes uncredited help of Rosalind Franklin and Maurice Wilkins. And when they discovered it, I asked Dr. Watson, well, when you discovered it, did anybody suggest you patent it? And he looked puzzled, and he laughed, and he said, no, nobody would have thought of that. And I wouldn't have thought of that. But some unnamed Hungarian Nobel Prize winner did suggest it to him. And Watson thought this was insane and laughed it off. Essentially moved on and got a Nobel Prize instead. That was a pretty good concession prize, actually. The structure of DNA was not patented, but in the 90s, Watson was asked to head the Human Genome Project for the NIH. Now, the Human Genome Project was an international effort to develop a map of the human genome, because if we know where in general genes occur on the human genome, we would be able to target further and future research into particular genes that we could find were disease genes and develop cures. It was a great medical project, basically the equivalent of the space race. The Human Genome Project was divided into tasks that were assigned to different research centers all over the world. James Watson was in charge of the U.S. Effort. When he was working for the NIH project of the Human Genome Project at the time. And there came to be a conflict.